Hi. So there has been a lot of confusion regarding the Provident Fund dues for employee and workmen for a company in liquidation. We are going to deal with some of these issues, why these issues come into being, and what the exact confusion is, and what part of it can we solve or not. So let's get into it. First thing we need to understand is what is the Provident Fund. So there is a definition in the Provident Fund Act, and you can go through it. But essentially, you need to keep in mind three things. When a person is employed in a company, he chooses, or sometimes if the company is big enough, there is a requirement by the company that a part of his salary or a part of his wages, we'll be using the term salary for salaries and wages, a part of his salary will be retained by the company, by his employer, and the employer will give it to the EPFO, that is the Employee Provident Fund Organization, to invest in the name of the employee. Now, will an employee do this? Because whatever contribution, whatever deduction an employee makes from his salary to be contributed towards the EPFO, the employer will make at least a matching contribution. So अगर आपकी सैलरी 10 रुपए है और आपने 1 रुपया ईपीएफओ में डिपॉजिट करने के लिए अपनी सैलरी से डिडक्ट करना अलाउ कर दिया बाय द एम्प्लॉयर, so the employer will give you a further 1 rupee, making your entire salary as 11 rupees. और ये पूरा का पूरा पैसा ईपीएफओ में डिपॉजिट होएगा, which the EPFO will hold in the name of the employee. And after a certain time, after certain formalities, the EPFO will invest this money, and the entire proceeds of this investment, the entire profit earned out of this investment, including the principal, ये जो 2 रुपया आपने डिडक्ट करा इसके ऊपर जो आपने प्रॉफिट करा, वो पूरा का पूरा एम्प्लॉय को मिल जाएगा. सो इसके दिस इज द स्कीम एंड इसके लिए पीपल अलाउ देयर सैलरीज टू बी डिडक्टेड. And you have to understand that this is money held either by the employer or by the EPFO in the name of the employee. This is the asset of the employee. This is not the asset of the EPFO or the employer. This is the asset of the employee. ये उसकी सैलरी का पार्ट है, बट उसको पे नहीं हो रहा है, उसको बाद में पे होगा. Thirdly, if the employer misses making these payments, then the EPFO charges the employer interests and penalties and damages. Interest 12% के rate पे होता है. Apart from that, there are also penal provisions. Now, this amount payable by the employer to the EPFO is not an asset of the employee. This will be paid by the employer to the EPFO. Employee does not come into the picture. So this is similarly gratuity के लिए. Now, gratuity में the employer has to create a fund that if the employee has stayed with the organization for a certain number of considerable years, then he will be paid off a bonus which is called a gratuity, जिसका gratuity act में calculation दिया हुआ है. And the employer needs to create a fund. So the employer needs to create these many funds for the employees, जो कि टाइम टू टाइम उसको पे ऑफ करना पड़ता है, either to the employees or to any government organization including the EPFO. And this is how the Provident Fund comes into being. Now, what are the statutory provisions in liquidation? First thing, as you are all aware of, is the waterfall thing. Where is the thing? So first thing is the waterfall, that the workmen are treated in 53(1)(b)(1) and the employees are treated in 53(1)(c). Now, there is a debatable issue that the payment to be made to the EPFO, which is a statutory body, a government organization, तो उसको जो payment आपको करना है, that can be treated as a government due. Now, this amount payable by the insolvent employer to the EPFO, should it be treated under 53(1)(b)(1), 53(1)(c) as salaries, or should it be treated as a government due? Which is a debatable issue. There is no clear consensus on it, but this is a question we need to be aware of. And of course, if we do not agree on anything, but we agree that there is an amount that is payable by the employer, then everything falls under 531F, which is any remaining debts and dues, which is a very vague term. Another interesting thing is the workman in IBC has been defined as per the Industrial Disputes Act of 1947. Now, that act defines the workman. Just before that, it also defines wages of a workman. In the wages of a workman, there are many different things, but it also includes any contribution to any pension fund or provident fund made by the employer or to be made by the employer or payable by the employer. So वेजेस में हमारा प्रोविडेंट फंड का कंट्रीब्यूशन आ गया. अगर वेजेस में प्रोविडेंट फंड का कंट्रीब्यूशन आ रहा है, so provident fund should immediately go to 531B and C, which are in priority to many other payments. But again, it can be debated कि since it is payable to the provident fund, it is amount due to the central government and the state government, which we will try to look into more in the subsequent slides. Now, the interesting thing is there is another section in the IBC which is 36(4)(a)(3), which says that any asset which does not belong to the liquidation to the corporate debtor will not form a part of the liquidation estate. अब ये जो प्रोविडेंट फंड का पैसा था, ये कॉर्पोरेट डेटर का, कंपनी का तो था नहीं, ये था वर्कमैन का, एम्प्लॉय का, तो ये लिक्विडेशन एस्टेट का पार्ट नहीं होगा. अब अगर ये लिक्विडेशन एस्टेट का पार्ट नहीं है, तो फर्स्ट थिंग, लिक्विडेशन में 53(1) में जो हम डिस्ट्रीब्यूशन कर रहे हैं, ये उसका पार्ट नहीं होना चाहिए. Secondly, the question arises, is the liquidator allowed to touch any asset which is not a part of the liquidation estate? फिर इस फंड का क्या होगा? Thirdly, which happens in most of the cases, this company is insolvent. This company has been NPA for like 4 or 5 years. It went through insolvency. It failed in insolvency. It has come to liquidation. इसके पास प्रोविडेंट फंड, पेंशन फंड, ग्रेचुइटी फंड के लिए पैसा नहीं बचा होगा. There is no such fund in existence for most of these companies. So one thing is, this is a violation. This is a statutory violation of the respective provident fund, pension fund, gratuity fund acts. Secondly, अगर ये फंड एग्जिस्ट ही नहीं करता और प्रोविडेंट फंड का पैसा इस फंड में से देना है, तो क्या प्रोविडेंट फंड को कुछ देना भी है? बिकॉज वो पैसा तो एग्जिस्ट ही नहीं करता. वी विल सिंपली गो एंड ट्रीट आवर लिक्विडेशन एस्टेट अंडर 53(1) और हम ईपीएफओ को पूरा का पूरा इग्नोर कर देंगे. इज दैट अलाउड और नॉट? Now, the questions which the courts of this country have tried to answer time and again, and we have reached some very interesting conclusions. So, if you're a liquidator in a company and you have dealt with EPFO, you will know that the first thing EPFO will throw at you is the case of precision fasteners, which has been a big win for the EPFO, and every EPFO department will quote this case to you at some point or the other. मुंबई में precision fasteners के केस में ईपीएफओ ने लिक्विडेशन एस्टेट में प्रॉपर्टीज अटैच कर ली कि प्रॉपर्टीज हम बेचेंगे, एंड द एनसीएलटी मुंबई साइडेड विद द ईपीएफ दैट इंस्ट्रक्टिंग द लिक्विडेटर दैट यू sell off these properties but you clear the arrears of EPF in entirety, in priority before any other creditors, whether you have a provident fund created by the company or not. We don't care, nothing doing. EPF will be paid in priority. The same thing happened in the case of Alchemist versus Motherware in NCLT Delhi in 2019, which was also upheld by NCLAT. Again, the same judgment, nothing doing, EPF funds will be paid in priority. Now, a thing that has been quoted again and again in such judgments has been a thing called right to life, which says that any other payment under section 53 is a payment for property. It is a commercial thing. However, the payment of EPFO towards the salaries and the wages of the workmen and the employees is a requirement for the right to life, which cannot be withheld by any authority. Again, in the case of UCO Bank versus EPFO, the High Court of Madras had the same opinion. EPFO proposed to sell off the property, attach the properties, and it proposed to auction off the properties. High Court of Madras agreed with EPFO that the EPFO was within its power to issue the order of attachment. वो attach कर सकता था, बेच सकता था. High Court Madras agreed. Now, a different judgment was given in the case of Lanco Infratech, where the liquidator was Savan Godiwala, which said that liquidator को gratuity की payments करने की जरूरत नहीं है. If there is a fund under section 36, it will pay from that fund. If there is no such fund created, तो liquidator पैसे कहाँ से देगा? Anyway, the liquidator will only deal with the liquidation estate. Any properties outside the liquidation estate, the liquidator will not deal with them. Secondly, if there is a fund not created by the company in respect of such payments, then the liquidator may not pay it. Now, this is in contrast with the order already upheld by NCLAT in the Moser Bear case. तो basically NCLAT ने दो contrasting judgments दे दिए जिससे पब्लिक कंफ्यूज हो गई. एंड दैट इज हाउ इट स्टैंड्स एज ऑफ नाउ. 2019 में 2020 में मोजर बेयर और लैंको इंफ्राटेक के केस में एनसीएलटी ने दो अलग जजमेंट्स दे दिए. देयर हैज नेवर बीन अ थर्ड जजमेंट कंफर्मिंग और नॉट कंफर्मिंग द टू, एंड ये मैटर कभी सुप्रीम कोर्ट में गया नहीं है. सो दिस इज वेयर वी स्टैंड. In prudence, you can assume that the latest judgment of NCLAT of 2020 should stand, but this will remain contentious because anytime you go with this judgment, the EPFO will throw the judgments of precision fasteners and Moser Bear at you. Another question that has arisen is, this was not in liquidation, this was in insolvency, that what will happen to the interest and the damages and the penalties. So NCLAT in 2019 gave a judgment on it that this entire amount in a resolution plan needs to be paid, and the remaining amount of the resolution plan was distributed between the creditors. There's still no answer as what should happen under under liquidation. So this is where we stand. Brings us to our three questions. In the case of liquidation, are the interest and damages payable and at par with the principal EPF dues? Now, in our opinion, no. Because the interest and damages are not at par with the principal EPF dues. The principal EPF dues are dues payable towards the workmen and the employees, which take a precedence, whereas the interest and damages are payable to the EPFO, which is a government organization, which is a statutory due, which comes much lower in the waterfall. So no, interest and damages are not payable and are not at par with the principal EPF dues. They rank much lower, but this has not been clarified at any time. Secondly, as a statutory provision, we need a reconciliation between section 36 and section 53. If the liquidator is not allowed to touch assets which are not payable by the corporate debtor, and the provident fund is not an asset of the corporate debtor, then is the liquidator liable to pay off the PF dues of the employees? Are the employees even entitled to claim these provident fund and gratuity fund dues from the liquidator? There's no answer to this, mainly because the dues of the workmen are being dealt here, and the provident fund dues, which are also the dues of the workmen, are being dealt here. So whether the liquidator is supposed to pay this to the extent the fund is available. In the most of the cases, the fund is not available, so this thing will eventually not get paid, whereas this is paid in priority. So whether the liquidator is required to pay this or not, we do not know. This needs to be clarified at some point by the legislature, by the IBBI, but right now this is a confusion for the liquidator. Thirdly, what happens, which is the general case, what happens when no fund is created for PF or gratuity or pension scheme or any such thing, What happens when such fund does not exist? So section 36 becomes invalid. As soon as section 36 becomes invalid, section 36 was created in order to prioritize the payment of PF and gratuity. As soon as there is no fund created and this entire fund has gone to section 36, जिस चीज को हम प्रायोरिटी में लाने की कोशिश कर रहे थे वो नॉन एग्जिस्टेंट हो गई. So again, what happens when no fund is created? This is a violation by the corporate debtor prior to liquidation. What happens then? We do not have an answer. And these are the open-ended questions left to the liquidator. Thank you.